afternoon. My name is Oliver Westmoreland. I am an IC registered level 3 immigration advisor and I am senior immigration lawyer with GSN Immigration. Please subscribe to our YouTube channel and click on the bell icon so you can continue to watch our extremely interesting videos about UK visa and immigration advice. Today's topic is this: child. Can they join their parents in the UK? Simple as that, really. I'm going to give you a brief overview. I'm sure that Mr. Shah is going to have a few questions about this. First of all, in English law, most of the time, a child is a person under the age of 18. Mostly. In this context, mostly so. If the parents hold visas, like working visas, possibly study visas, and child hasn't come with the parents for whatever reason, child can apply to come and join the parents in the UK. Let's say parents hold a settlement, or maybe one of the parents holds settlement. Again, child can apply to join the parent or parents in the UK. Most certainly, if parent is British citizen, child can certainly apply to join parent or parents in the UK. This is fine, but there's one overarchingly important issue, which is sole responsibility. This is a very funny set of rules. Might not seem particularly logical, but it's the way that things are. It's the way that the law works. If both parents are in the UK, there is no problem. Child can apply to join the parents in the UK. If only one parent is in the UK, then you get complexities. The other parent might be dead, in which case there's not really any problem. Child can apply to join the surviving parent in the UK. It's not really problematical. In many cases, the other parent is alive and well, perhaps. Maybe the relationship is split up, so on and so on and so on. Then you run into very difficult and complex issues, the issues of sole responsibility. I'm not going to spend a great deal of time explaining this. I'll explain to you in a brief and basic way. If a child applies to join a parent in the UK, either parent is alive and well or fairly well somewhere else, the parent in the UK has to show that they have sole responsibility for the child. That doesn't mean literally and exactly what it says. It means either that or something similar. And it's an amalgamation of factors. Let's say the parent in the UK gives money to look after the child. The child is going to be somewhere outside the UK in many cases. Let's say that the parent in the UK gives the child money or gives money to the people who are looking after the child. That's a factor, but it's not an absolute factor. At least as important, the parent in the UK takes an active interest in the child's upbringing. In many cases, the child is looked after by grandparents, but other possibilities may be so. The parent in the UK, they keep in touch with the child's school, make sure that their education is going well. The parent in the UK, they look after, they take care of, they are involved with the child's religious upbringing. For some people that's more important than others, but it could be an important factor. The parent doesn't have to show 100% responsibility for the child. Sole should not be taken literally, but the parent in the UK must show in the legal meaning that they have sole responsibility for the child. If they can't, the application may be unsuccessful. Now, this applies to both under the Appendix FM, Appendix Family Member Applications, and also applies to visa applications and settlement situations. It applies everywhere pretty much. If the child is applying to join a parent who holds a visa, if the application is refused, there's no right to appeal. There is the right to administrative review, which is a process carried on by UKVI, UK Visa and UK Visa and Immigration. The same people who made the initial refusal decision. If it's an Appendix FM application, or to be slightly technical, if it's an application made on a slightly different part of the rules, Part 8 of the immigration rules, which is where the parents hold a settlement, if the application is refused, there will be right of appeal to the first tier immigration tribunal, which sits in England or United Kingdom, presided over by an immigration judge. Probably a legally more thorough process. Either way, there is a right of challenge. Appeal maybe rather better. There is a right of challenge. Let me tell you from my experience, some of these sole responsibility cases are unsuccessful. Sometimes the Home Office refuses, and to be brutally honest, sometimes the tribunal refuses them as well. It wasn't sufficiently proved. You can imagine it could be difficult. You have a parent in UK and grandparents or somebody somewhere else. Grandparents look after the child on a day-to-day basis. Parent in the UK is trying to show that they have sole responsibility. It could be very, very difficult. These cases can be very, very difficult, and you need a good lawyer to guide you through. There are requirements about, well, as you would expect, financial requirements, either specific or vague, accommodation requirements. Children, let me tell you, basic overarching fact, children do not have to pass any English language tests. There are no English language tests at all whatsoever. That's the basic thing. Mr. Shah, I'm sure you're going to have a few questions for me about this.
Yes, please. This is a very complicated topic, as we discussed earlier, and there are lots of people in a situation like this. In regards to appeal rights, am I correct? Some people will get a right to appeal and some people will not. Could you just elaborate again on that, please?
Yes, if the parents hold a visa, like a working visa or a study visa, there's no right of appeal. There is right to administrative review. Now, this is a challenge, but it's a challenge made with the UKVI, UK Visas and Immigration, who are the same people who made the refusal decision. Could be successful, but not always. Appeal, this is held before the first tier tribunal in UK, presided over by a judge who is a qualified and experienced lawyer. Maybe the chances are better, but some cases are much harder than others. And to be brutally honest, if it's a very weak case, it's not worth spending the money on an appeal and all the expenses that involves, lawyers and so on and so on and so on. Even before the tribunal, maybe the rate of success might be a bit higher, but if it's a weak case, you want to think very hard before paying the money to your lawyers.
Sure.
I think before you start challenging, you want to try and get good advice beforehand.
True.
And also, can I say, before making an application, you probably want to get good advice from a UK registered lawyer.
Yeah, that's probably the best thing to do, to prepare a strongest application if possible.
I mean, some people, they want to do it themselves because they think, I can do it, I'm educated, which is fine, but immigration law is always more complicated than it looks. And especially this area of sole responsibility is a very funny and difficult area.
Sure. And the appeals outside the UK can take easily, as we see, about a year or more.
However, administrative review has slowed down enormously, and it's about the same, so there is no advantage either way.
Wow.
A good thing about administrative review, it's cheap. It costs you £80. Appeal's going to cost you a lot more, probably. It could be £80 or £140, depending on how you do it, but you're going to get lawyers' fees unless you want to try and do it yourself, which is not really recommended. It's too complicated.
True. And how many days does the parties have to appeal the refusal decision?
Well, in many cases, the decision is made from outside UK.
Yes.
It's quite generous, really. It's 28 calendar days from the date of receipt of the refusal decision. Now, should it be in the UK, which I suppose could be possible, it's 14 calendar days after the decision was sent.
Okay. More time for people who are outside the UK.
Well, I think things are more unreliable. We know what happens in the UK, don't we? We can't say what happens outside the UK so obviously. Different countries are different.
Yes. And if this application is successful, what does the applicant get usually? Is it indefinite leave to enter? Is it a visa?
Good question. I can't give you a really simple answer like everything else. Under Appendix FM, it's going to be the child will get a visa, and it'll put them in line with maybe the other parent. If it's another part of the immigration rules, child can actually get indefinite leave to enter, which means that the child is granted settlement even before they come to the UK.
Brilliant.
It's a bit strange and complicated. I mean, you need to get advice from a good lawyer about this. If it's a visa, that the parent holds a working visa or a study visa, then the child will be granted a visa in line with the parent who has a visa as well. They will be granted in line.
Okay, so it really depends what parents may be holding on to.
Yeah, it depends completely on that. But I mean, if the child gets a visa, they will have a route to settlement in the same way that the parents do.
Fantastic. Okay, that's all. This was lovely to dive into.
No, that was easy. I thought it might be more difficult.
Thank you so much for today's vlog, and we see you in the next one.
See you next time. Goodbye.